going to be the main thing that I talk about. But I hope that the structure, the way we go about building the ID case is the same method that you can use in building a confession case, where you're going to defeat the confession. And that it is the same way that you're going to defeat a circumstantial evidence case. Or harder yet, when there is ID plus a confession plus circumstantial evidence. That's when the real challenge takes place. But I will say to you, you can win cases even when that does occur. You can win criminal cases that you never dreamed you could win. Now, we're going to use the ID case as our vehicle today. And let me say at the start, the Innocence Project, Barry Scheck and his colleagues and so forth, and people that work with him around this country, the last number I heard is that there were 216 innocent people who have gone back out on the street after serving 10 years, 20 years, more than that. And that 80-some% of these were ID cases. Now, what does that tell us? It tells us that eyewitness evidence is just terrible stuff. It ought to be kicked out under $1. That's my ruling, but I'm not a judge, of course. It's that bad. Now, the 216, that sounds like a lot. But in those 216, who are the ones who got free? The ones where there was DNA or that kind of evidence which would conclusively prove that they didn't do it. That's the only way they were able to dispute this. And so there are all kinds of people in prison because it is a crapshoot when you get people identifying some particular person as the robber, the rapist, or whatever it happens to be with ID evidence. So I have no qualms whatsoever, even if the defendant has told me he has done it, in fighting eyewitness evidence. There is around the states now some movement and actually some legislation passed that makes it so that ID cases are considered a little different, and there's legislation saying, as the scientific tests tell us, that if instead of having a lineup or a photo display where people look at all of the defendants or possible defendants at once, they have to do it one at a time. Because what's the tendency of people when they're looking at, say, a lineup with 6 or 7 people in it? What's the tendency?
Pick the person that looks the most similar.
The most similar, yes, in their mind. And that person gets convicted if it happens to be that your defendant is the one who looks most like. That's why eyewitness evidence is so dangerous. But confessions. When we learn more about confessions, and we learn how the detectives go to school and learn how to get confessions, when they learn to shout or to be friends, but Jeff, putting the person on ice, all of these different techniques. And we have overpowering detectives beating up on somebody who doesn't have the power to resist, the strength to resist. And they're falling into the trap that I have seen many defendants fall into. Well, of immediacy. I get to go if I will tell them what the score is. And I'm thinking only of today, not of the fact that I'm going to serve decades if I get caught. Now, so the ID case is the vehicle, but we'll discuss a process of developing a defense that is available or useful in other aspects as well. Let me tell you that how all this started with ID. This is a case in Denver, Colorado, East High, and across the street was a mom and pop grocery store. And Pop was known as the candy man because East High students who couldn't afford the candy would come there and he would give them the candy. The case arises because one day somebody went in and was robbing Mom. Pop and Mom lived in the back. Pop heard some disturbance and came out and went for the gun under the counter. We all know how that happens. And of course, Pop gets shot right in front of Mom. I happen to have some time to work on developing the ID case because that was what it was all about. My defendant was caught with newspaper clippings of this homicide in his billfold, in his pockets, etc., as well as having a gun not connected to that particular homicide. And so that's kind of my model as I go through here. I had the time to work on that case. And I asked myself, what does really happen in identification cases? And yeah, we've got 2 hours, less than 2 hours here. And it took me much longer than that. So while I'm going to have you working with me and helping me on this, I'm going to get through in fairly short order. What it was that I decided was what happens in identification cases, and what we know at the start is that right after the homicide or the robbery or whatever it is, the detective, this is just standard procedure. It almost is just human nature. The detective someplace in the interview with the eyewitness said, do you think you could recognize this person if you saw him again? And what's the answer?
Yes.
Okay. You know, they don't often say yes. I could definitely do it. What do they say? Maybe. I'll sure try. I don't know, but I think I can. Those are words of what? Of doubt, of uncertainty. And so this is going to be important to us, that we start with uncertainty. The uncertainty right after the event takes place. Now then, we know what our trouble is, don't we? That when it comes to trial, what's our witness going to say?
Right next to the
Yes, he's the one. Are you sure? Yes, 100% sure, and so forth. Are they lying? Okay.
They don't believe that they are.
They don't believe that they're lying. Now, it is that in the meantime, certain events have taken place. Now, note what we're doing here. We are not going into this trial with our major central theme being prosecutor failed to prove each and every element beyond a reasonable doubt. Dozen inconsistencies and so forth constitute reasonable doubt number 12. We are not doing that. And let me take time out to say, I'm not against using a reasonable doubt, presumption of innocence, unanimous jury, all of these, and the burden of proof being on the prosecutor. But they aren't just legal concepts floating out here in space. They do what? Each one of those constitutional protections protect innocent persons from being unjustly convicted. That's what's important. Not that you toss these things out here in a vacuum for the jury to consider, but everything you do, including the evidentiary rules, including the constitutional principles, are for the protection against innocent persons being convicted. That's what's central about this. So let's go to work on our ID case. And I know I sound as if I don't want your participation. I want your participation. I want your questions. I want your challenges. I want your contributions to what this is all about. What we know is, whether it is an ID case or any other kind of case, this is the way we start. This is Johnny. Now, we have been taught to be analyzers and to think about things and so forth. And the other day, I said to you, we wanted to take you from being analyzers and make you advocates. That means you don't have to be concerned about whether Johnny is guilty or innocent. That's not your job. I've checked with a number of people who are experts in ethics. Just because I know that Johnny is guilty doesn't mean that I have to go in and plead him guilty. Okay? Let me repeat that. Just because I know that Johnny is guilty, just because I believe that Johnny is guilty, doesn't mean that I have to go in and plead him guilty. Every defendant is entitled to your taking the position that he is innocent and going in and fighting the case. And when we do that, what's going to happen is that there are going to be protections in the law. There are going to be less innocent people convicted, and we are going to be better off. So, it is not a matter of anything other than your job is limited. You're not the decider. Your job is an advocate. And so you start with, Johnny is innocent. The next question is, how is Johnny innocent? Well, in the ID case, it is because the eyewitnesses are mistaken. Look how in seconds we are way down the line. We know that our central theme in this case is going to be that these eyewitnesses are mistaken. It is going to be that Johnny is innocent. And therefore, that we're that far down the line. Okay? Now then, being that far down the line is where we really start to build. And we build these cases with a book, okay, with the dividers, because it is so easy, once you have the book with the dividers, or your laptop, or however you want to do it. And here is an idea for cross-examining the prosecution's star eyewitness identification witness, and here you go, and you're writing down the ideas for the cross-examination of that witness. Now, so we've got this available, and you don't have them in front of you, so we're going to kind of do it in space here while we would be doing it in the book if you were by yourself or with another group brainstorming the case. Now, we're going to look at how this does really occur. Because in the closing argument, we are going to have a chapter of argument that says, how did it happen that this mistaken identification took place? How did it happen? How did it happen that it went from uncertainty right after the event to certainty here in this courtroom? Because if the jury's focus is on what happened here in the courtroom, Johnny did it, he's the one, I'm 100% sure. The jury goes into the jury deliberation room, and that's their focus. We're through. We're through. So, tell me about where our focus is going to be.
At the beginning,
It's going to be at the beginning. Okay, why?
that's the moment in which we need to accept and express to the jury,
Yeah.
because that's the moment in which they made the initial decision.
Yeah. And we're looking for words of uncertainty. Okay. If they say, I think it's number 3, the words, I think. In other words, we're going to take those words. We are going to put those words under a microscope. We are looking for words of uncertainty. Because in this chapter, in the closing argument, when we're talking about right after the event, when there was uncertainty, we are going to be discussing in detail every word of uncertainty. Now let's look a little more at how this all occurs. I happen to think that, and my experience is, that what I'm describing is not just something that some defense attorney made up, but is actually what happens in these cases. Let's take our case that the robbery murder takes place. The detective talks to the Mrs. Hurt, who was mom, talks to a customer who was coming in, and when the detectives talk to these witnesses, almost inevitably, I have learned by experience over a period of time, the eyewitnesses say, essentially, when will we hear from you, Mr. Detective? The detectives have lots of cases. They don't want people calling all the time. And so they say, come on, help me. The detective says what?
When we have somebody.
Yes. We will be in touch with you. And they probably aren't going to say when there's a break in the case. But what does the witness hear when there's a break in the case? Otherwise, the detective wouldn't be calling. And so, 10 days later, the phone rings, and the eyewitness answers. And the detective says, would you come down to the police station and look at some photographs? Now you're this witness. What thought is going through your head? They caught the guy who did it. And so, while there are millions of possible robbers, it gets reduced to what? Those people who are going to be in the photo display. You see how innocent all this occurs? Now, what about that witness? We need to explore the witness's mind. The witness has been robbed or was present when there was a robbery. What's their motivation? And my drama friends always emphasize to me when they are playing a part, you always have to know your motivation. And in putting together cases, the motivations of the various people are tremendously important in analyzing, because with the motivations you explain to the jury why they're doing the things they're thinking, why they're thinking the things that they're thinking. And so, what about our witnesses? They what?
Want to do the right thing.
Okay, they want to do the right thing, and what? They want revenge.
And they really want to help.
They want to help. This is a robber, in the case that I'm talking about, a robber murderer. We want to do something about this. Look at their mindset. We want to help solve this. Well, how do we solve it? We get somebody. Now, are they saying just anybody? No. But does their psychology cause them? Because after all, how do we look upon the police if we're a witness now?
They're the good guys.
Crawl into the skin of the witness.
They're the good guys.
They're the good guys. In addition, they are what? Problem solvers? Detectives? They know about this kind of thing, don't they? Ah. Now, the way I'm going to state it, you know that it doesn't make any sense. But when the police call and say, would you come down and look at some photographs, the witness is thinking they caught him. And they want, after all, it's been 10 days or whatever period of time it has, and nobody's been caught. Wow, there's a robber out on the street, and it hasn't been solved. Okay, what I'm talking about is going through, getting into the skin of those witnesses. What's going on with the witness?
You know, one thing that I know is that people love cops because they think they're the good guys, but also they think that one of these people has to be it. They have to be in that group, or they wouldn't have given me these 6 pictures or 12 pictures to look at.
That's right. The cops are authority figures in what? In robberies. I mean, these detectives are in the robbery squad. So, if we had any doubts about it before, here are the detectives, and we're looking to the detectives. And so we go down and look at the pictures. And let's say, and there are various ways, you have different ways in your different jurisdictions, but let's say that we've got 6 pictures here in 2 rows. Now let's think about what happens. First of all, we've taken the world of possible suspects, haven't we? And reduced them down to 6. See why the scientists now say that if, instead of they're being shown all at once, where they pick out the one that looks most likely, but it should be that they are presented to the identifier one at a time. And that reduces, and there's legislation in some states in process to make it so they have to do it that way. I don't know whether anybody has actually passed that and made it so. But here we are with these 6 pictures. Now then, once again, put the actions under a microscope, okay? As to what's going on. So the witness looks at number 1, and goes to number 2, and number 3, and number 4, and puts her finger on number 4, your defendant, and looks at 5 and 6. What are we going to say about that? What's going on?
She wanted to see the rest of them before she committed.
Yeah, she wanted to see the rest of them. Why?
Because she wasn't sure.
Because she wasn't sure of number 4. And we are never going to let that jury forget the doubt. We're never going to let that jury forget that she had to go on to 5 and 6. Because if she was sure that it was number 4, she would have stopped with number 4. Okay, once you know what the situation is, there are strong arguments to be made.
Can we stop this? Let me ask you this. I've never seen that in a police report. You're assuming, we're interviewing the witness and pulling this out of them, aren't we? Because I've never
Well,
seen
let's back
that
up a
before.
little bit, but we'll get to it a little later. What you want to do, your discovery, yes. But you want to file a motion to suppress. Why do you want to file a motion to suppress with all the grounds that are available and so forth, so you can get a hearing? Okay? And that's where you ask your questions. Okay? I'm from Colorado. We talk about panning for gold, but even those on the East Coast can have this too. The old prospector dips down into the stream, and he gets a bunch of junk, and he shakes it down. And if he finds 1 nugget, that's pretty darn good. If he finds 2, it's a bonanza. Okay? And then he throws the rest of it away. And whatever the case we have, we are constantly looking for more stuff, because out of that stuff is a nugget or 2. And there are great advantages to the defense, because all we need is a nugget or 2, and use the devices of emphasis to make it central in the case. So, we find, because in the motion to suppress, the hearing on the motion to suppress, that this is what occurred, that she picked number 4 and looked at 5 and 6. But of course, the question is going to rise in your mind. What if she comes to number 4 and says, that's the robber? Now, let me tell you, this doesn't work as well as when she goes on to 5. And I haven't solved this problem completely yet. But she comes to number 4 and says, that's the one. Then she did what? The witness jumped to a conclusion that it was number 4 and didn't even look at 5 and 6. Defense lawyering is for imagination, okay? And having the mind of the advocate, I am going to find a way to win this case. I am going to take, it's not my job to decide on consistent things. No, my job is to win this case. So, the detective says, and it is amazing how often this happens, and I've talked to people in other jurisdictions who say the same thing. When they pick number 4, the detective says something like, well, do you think you could pick him out in a lineup? Whether those are the words or not. Or, even, could you attend a lineup tomorrow morning at 10 o'clock? What's the message? Okay. Yeah, you got the right one, otherwise there'd be no use in a lineup, right? Okay. So there are all kinds of messages that are being sent that are not explicit messages, but they are messages which are received through implication by the witness.
And if you say, could you do it right now, that means the guy's in custody. You've already arrested him.
Yeah.
Or we're holding
Yeah.
him.
Whatever.
Yeah.
If we're going to have a lineup, means you have picked the right person. Now, we started, and I might as well give you the further outline. The uncertainty goes to trial. Okay? Now then, and I don't want to cover this completely yet because we have to get into the lineup and so forth, but there is a process where it goes from uncertainty to certainty at the trial. He's the one, and I'm 100% sure. And if you let that be central, you're through. Innocent or guilty, it makes no difference. That is a conviction. So there is a process. I'll give a suggestion. Has that process already started here when the detective says, okay. Has that process already started when the detective asks, since you're sitting here, would you sign the back of the picture of number 4 and date it? Does that suggest that she has picked the right one? Does that reassure her that she has picked the right one? Oh, yeah. And incidentally, over and over and over again in the motion to suppress hearing, these witnesses are, and I don't even have to work hard to get them to tell me the things that I need to make this case. But it's cross-examination that you're engaged in. Did you happen to notice when you picked number 4, you happen to notice Detective Johnson, the expression on his face? And over and over and over and over again, the answer was yes. He seemed pleased. This witness looked at the detective to see whether we passed the test or not. Now, look how much of this is not the facts, but are reasonable inferences from the facts. This case against identification is substantially based on arguments that you take from the facts rather than the facts themselves. I am arguing about a process that takes place in her head. I am arguing without her admitting that she looked at Detective Johnson to see whether she had done right, from the fact that she noticed the expression on his face. He seemed pleased. What is that? A suggestion that she's right and reassurance. Is there going to be suggestion and reassurance every step of the way? Yeah, and we'll demonstrate. So, we're going to the lineup tomorrow. There are the pictures. Guess what happens over and over? The detective doesn't take the pictures away. And guess what you're going to do? You're going to study picture number 4. Tomorrow at 10 o'clock, you come to the lineup. The fact that there is a lineup, suggestion and reassurance. Now note that we need to come up with this telling the jury the very process. When we're in the closing argument, we're going to tell them that there was uncertainty, and we are going to have a chapter on the uncertainty that goes to the certainty, and we're not going to spend a lot of time on the certainty, okay? And it is through a process of suggestion and reassurance, and we're going to show the jury exactly how every step of the way there was suggestion and reassurance, and that's how it got from uncertainty to certainty. Now, see why we're doing this morning? Because this is the kind of process you're going to do in the ID case. You're going to do a similar process in the confession case. You're going to do a similar process of thinking about how it actually happened, what arguments can be made. You are going to get into it. You're going to put it under a microscope. You're going to delve deeply into it. But you know there's a great advantage to it. That is, once I had spent the hours that it took, okay, it sounds so simple this morning, I know, but it took hours before I understood this. Once you get it, I tried ID case after ID case after ID case, but the same arguments, just changing the facts. The DAs never understood what I was doing, in spite of the fact that often it was different DAs. And apparently they didn't know that there was a method that was involved. And I never lost an ID case after that, using this method. Because I suggest to you that it's real, that it explains why it goes from uncertainty to certainty. I have to admit, there was one case I was well on my way to losing, I was sure. And then a police officer takes the stand, who testified that he's coming to the scene and actually meets my defendant, and he has a green and gold ski mask, which he drops, and it became evidence in the case. There was no ski mask listed in the evidence. I'm not exactly winning this case. There was a lot of circumstantial evidence in the issue. And I said, you know, the gods are with you at times. After ascertaining that this police officer would have taken this evidence and put it in the evidence lockup, that he would have done paperwork on it, he would have done all of this kind of thing, the tremendous care they take with evidence. And then I said, officer, if the judge will give us a recess, I'll bet you can go get this ski mask. You understand, I thought I was losing. I don't know whether I would have done that if I had thought I was winning. There was the longest silence. Fine, because I wasn't going to break it. And the judge leaned over and said, officer, can you go get the ski mask? The answer was no. That bailed me out. So I don't tell you you win every time with this. Now anyway, we go to the lineup. And now every word, every picture, every piece of evidence you want to look at in depth. Because we are still searching for what?
Suggestion and reassurance.
Okay, we're looking for that, but we're still looking for uncertainty. Yeah. Incidentally, when number 4, what did the person say? And almost always it's still uncertainty. This looks like him. This looks like him except for the eyes. This looks like him except he's a little younger, older, what have you. There's still evidence of uncertainty. So we are looking for all 4 of these things during all of the trial. Since I've already got us off course, I'll tell you about this particular case where Mrs. Hurt was mom. And in the closing argument, okay, there had been 7 times when Mrs. Hurt had an opportunity to point to Johnny and say, I'm positive he was the one. 6 times before, it was, this looks like him except for the eyes, this looks like him except for the younger, older, all of this kind of thing. And the 7th time, of course, in the courtroom, he's the one, and I am positive. So, this district attorney was not a candidate for Rhodes Scholar, you understand? And I understand that. So I'm not saying that you should go back and try it with a really brilliant DA without thinking it through. But I knew that Hoadley was not the brightest. So I put on the book chart this listed the 6 times with a mark and the 7th time here in court. And we took the stand with the foot chart on it, the 7 times listed, and said, now ladies and gentlemen, so that Mr. Hoadley won't have any difficulty in answering how it is that she had 6 times, and every time she hedged, every time she was uncertain, every time she was unsure. And only when she's in the courtroom, did she say that she was positive. We'll put this stand here with this list so that Mr. Hoadley can deal with this when he comes up here. We put it right by. Hoadley, you're entitled to some humor here. Hoadley's way of dealing with this was to come up, tear it off, wad it up, and throw it on the floor. And as he spoke, the paper was coming apart, and the jury was watching it. We go to the lineup. And the lineup, depending on your jurisdiction, they're all there. They all walk around in a circle. They do various things, whatever it is that's the routine. Okay. And so in the motions hearing, if we don't have the information otherwise, we want to know where in the process that the witness chose to decide that it was, we'll keep it number 4, but they changed the number for the lineup. Okay, when did the witness write down number 4, circle number 4 in the lineup as being the one? What are we after? We're still after evidence of uncertainty. So it was 3/4 of the way through. Why? Because the witness wants to be what? Careful, certain, etc. But it took 3/4 of the way through. That's evidence of uncertainty, isn't it? Or you could pick it out right away. Jumping to a conclusion, because after all, they'd studied the picture the day before. Now, these cases, a number of cases, and I've discussed it with people in other jurisdictions, are remarkably similar, the process that takes place. But there will be a little bit of difference, and that's why you need to go through that hearing, so that you can pick out those things which are helpful to you, and those things that are not helpful to you, don't ask. So it's the way to winnow out those things that are not useful to you. Now then, we have the lineup, and the person circles number 4, and tells the detective or writes, depending on your jurisdiction, signs it, whatever. And there is in some legislation requires a confidence statement. How confident the witness is that it is number 4. What you're looking for still is what? Uncertainty. This is what you are building. Because your focus is not going to be here. You're going to get that jury's focus off of this onto this. And incidentally, part of your closing argument, as far as Mrs. Hurt being 100% certain here in this courtroom, there's a part of your closing argument that says, ladies and gentlemen of the jury, I can go to Los Angeles or New York or San Antonio, any courtroom in the United States of America, without knowing anything about the case, and point to the defendant because he's sitting at defense counsel's table and he's not the one who's the attorney. It is no trick at all There's even a sign that says defendant, which I always scooted to right in front of the defendant. It's not difficult to do that. So you're going to disparage. You're going to disparage the courtroom identification. Not only is it the product of suggestion and reassurance, but it's shooting fish in a barrel. Yep.
I have a question that's probably a little bit off the path, and maybe you're going to talk about.
I don't think so.
What about if it's the police officer that identifies your client?
Well, first of all, what do we, yeah, join with me in this. What about Officer McIntosh? First of all, he is what?
He's a police
A
officer.
police officer, okay? So he has some interest in this. Now, probably he's not going to have gone through this procedure, is he? Any kind of procedure. So, he's not a Superman. And we should have the same tests, the same procedures to test his identification as we have for other people. And they didn't do it simply because he is a police officer. That's kind of surprising. I've seldom had it so that the police officer was an ID witness. They are witnesses to certain things happening and so forth, but not so much ID. So I'll bet if we brainstorm that more, we can do even better yet.
When it is, say they've looked at video, you've got police officers, they've looked at the video from the robbery, and they're saying, I think that's Johnny. And they're in their room and they're saying, I think that's Johnny, and maybe they're relying on a snitch to say, yeah, I think that's Johnny too. I hear you saying that you want to have an evidentiary hearing, a motion to suppress their identification. My concern is to have 3 cops that were all in a room. I know they're going to walk into trial and they're going to say, it's Johnny, it's Johnny, it's Johnny. Yeah, I'm certain it's Johnny. And what would you do?
Okay. First of all, there's a kind of cross-examination we mentioned in this room yesterday, as a matter of fact, and we call it collateral cross-examination. Now, as best you can, if you can get sequestration of the witnesses. But, you know, they have a lot of different ways to keep them being sequestered. And of course, you make that a point, that these police officers work together, and they're all here, okay? And then we're going to talk a little bit about inconsistencies later on, but the collateral cross-examination is one where they have gotten together on the central parts of their story, but they don't get together on these things which are just a little bit outside the bounds. And let me tell you that you're into an area that's tough, okay? But that doesn't mean we're defeated. So, yeah.
Steve, what about the improper suggestion in the lineup? It actually wasn't number 4 for me when I did a lineup. It was number 3. And there were suggestions that the police officers made to assist the identification. How do you get to the improper suggestion in the police station?
Well, first of all, that's not easy, and you and I, all of us know. And after Wade, I would be down there, and I would hear police officers talking to witnesses essentially about the case. And incidentally, if you happen to be the public defender who's down there for the lineup, be sure you take all the notes. You're a witness in the thing. If the police do improper conduct and they won't admit it, and you don't have other proof and so forth, I don't know what you do. I'm sure there have been much that I haven't known about. Okay, let's go back to the lineup for a little bit. Once again, we're looking for uncertainty. So, what did the witness say when the witness picked number 4? And still, witnesses are hedging. Now, they're hedging because they really aren't sure. See, I happen to think that if somebody pointed a gun at me or killed somebody in my sight, that I wouldn't do a very good job of identification. That's why I think so little of identification evidence is being valuable. But you've got to make that clear to the jury.
Because you're looking at the person who just got shot.
Yeah. And
What the gun?
weapon
The gun,
focus.
right.
You're looking at the gun.
Horrified,
See,
yeah.
they're coming after you.
Yeah,
Yeah.
yeah.
You know, I've had witnesses, and incidentally, you want to ask them about that gun. And I've had them describe that gun in detail. Now, I haven't told them. I've led them to believe that it's important that they be able to describe the gun. What I'm really getting at is that their focus was on the gun, yes.
Do you normally try to bring in like an eyewitness reliability expert to say where their focus is, where people normally focus, or what they?
Okay. I don't know how judges are treating you. If you can get an expert, the answer is yes. Okay. There are people like Elizabeth Loftus, there are other people who are experts in this field. I suggest to you that whatever field you're developing a case in, for example, in this, the Champion, the National Association of Criminal Defense Lawyers, and if all of you can't afford to be a member, maybe your office can be a member, or somebody can be a member, or what have you, and you get magazines like this, In the Eye of the Beholder, Eyewitness Identification Policy and Legal Reforms. And you can read what people say, and James Dole has written about it, and Patrick Wall has written about it. And there are some things on the internet, which as usual, some's accurate, some's not accurate. All of us need to, because I've yanked the rug from under you as best I can, relying on reasonable doubt and the burden of proof being on the prosecutor and all that kind of thing. What we are going to do, we're going in there head to head, and we're going to say their case for identification, and we're going to kill that case. We are going to take it on. We are going to attack. We're not going to rely on prosecutor fail to prove each and every element beyond a reasonable doubt. That's in there to protect from the conviction of innocent persons, but we are going to build a case. That's how we're going to win. And I will tell you from experience, this kind of thing put on, the jury, if you have created the fear of convicting an innocent person, which is the emotion upon which we win, it is your job is to create that fear of convicting an innocent person. When we do that, by showing how all of this occurred, and that uncertainty is really what it's about. This person was uncertain right after it occurred. The fact that they went through a process that made them certain is irrelevant. Okay. And you make it as irrelevant as possible. So anyway, at the lineup, we get it. So that whatever words of uncertainty, but the fact that the person then is charged is what?
Compliment.
Suggestion and reassurance. Yep. Notice that every step that occurs in the trial becomes suggestion and reassurance to that witness that that witness is correct. And then there's the charge and preliminary hearing. And the witness may receive depending on how tough your judges are at preliminary hearing, make the witness appear or not. The witness is either present there, has received a subpoena to be present at the preliminary hearing, or if not, may allow the detective to testify to it. Maybe the witness learns that it has been bound over for trial. What is that? Suggestion and reassurance. Okay, this is an easy test here. Everything is, we're going to build uncertainty, and it gets to certainty because of suggestion and reassurance. Yes?
I was, 10 years ago now, a reporter in Denver, and for a long time, and in preliminary hearings, I don't know where I'm at in Oregon now, but, and the standard is so low for getting past the prelim that it's hysterical. I mean,
Yeah.
almost any question, and it goes to trial. So it's
That's
ridiculous, and it cements this thing.
Yeah.
Yeah.
Where I practice, the purpose of the prelim is so that you can't, they need to have some non-hearsay allegations, so I think they would have to put somebody in there.
Yeah, I'm going to say to you that you have all of these different jurisdictions involved. Whatever it is about this process, because every bit of the process that took place in the case that we are putting together becomes suggestion and reassurance. Now then, the witness receives a subpoena for trial. Climb into the hide of this witness and tell me how you feel. How do you feel?
Important.
Yeah, you're important.
You feel
Yeah.
pressure to not say that you were wrong, too. I mean,
That's right.
Yeah. I mean,
you feel that pressure, like, I have to say the same thing, I have to be consistent. I don't want to look like a fool.
yeah.
I don't want to be a jerk who, ruined this poor guy's life, and now I'm up here saying that it wasn't,
Yeah, that's tough.
Resentful.
Okay, and there's the other side of the coin.
Resentful.
Okay, we got resentful, angry, and so forth, but nevertheless, they got him, right? Okay,
Vindication. Vindication.
okay, there's vindication. There are all of these emotions that are involved. There's the emotion we don't want to be wrong, so we don't let ourselves really think about that. But we don't have to think about that because
It wouldn't have gotten this far.
it wouldn't.
Yeah.
Okay, here's the important part, I believe. It would never have gotten this far if I had been wrong. Does any witness ever say, wait a minute, the detectives and the DAs weren't there? It's all up to me. They do not realize this. That's not part of their thinking. Now, we have been taught something about rational thinking. What do the psychologists say about people? And incidentally, because I'm going to tell on them doesn't mean I don't love people.
They're emotional.
They decide things emotionally. Okay? There is no psychologist that I know of who has ever said that anything less than 90% of our decisions, including the important decisions in life, They are made on the basis of emotion, and then we rationalize. I know that gas is over $4 a gallon. But you go to the car dealership and you see this red Porsche. Porsche company, I don't have the least idea how much gasoline, how many miles to the gallon. But nevertheless, you find out that this Porsche eats gas. I mean, this beautiful red Porsche. What are we going to do? Buy it anyway. You know, the blonde doesn't come with the car. Sorry. Those heavily clad young ladies don't come with Budweiser beer. So it's your job to expose the difficulties in the thinking of the witnesses. The witnesses themselves do not know that they are engaged in fallacious reasoning. The kind of fallacious, you watch them as you go through the process. Each step of the way they become more confident. Because it, as Ron said, it would never have gone this far if he was really innocent. And I'm sorry, I don't know your name. You're talking about there might be anxiety.
I'm Rob.
Rob, okay. Might be anxiety about whether I'm right about this or not. What do the psychologists tell us happens to people when there is anxiety? We find a way to take care of anxiety. Okay? We shove it down into our unconscious or whatever. This kind of psychology is useful in trying these cases. Because if you can put it across to the jury, they do understand it. And they all kind of laugh about it and so forth, but nevertheless, you see, you are creating a fear of convicting an innocent person. Never forget that that's the basis for virtually every defense I've ever seen. Fear of convicting an innocent person. You scare the hell out of the jury about somebody being in the penitentiary for a crime they did not commit. So the person is at trial. It would never, ever, ever have gone this far if I was wrong about this. And so by that time, there is what the prosecutors had been relying on for decades. Not recognizing until you deal with it with the jury that certainty and accuracy are not associated traits. And you need to discuss this on voir dire. Because everybody knows people who are certain of everything and they're wrong. Now let's go to some parts of this. There's an eyewitness, or there are two eyewitnesses. I'm talking about eyewitness identification witnesses, or three. And I've had people say to me, just after pleading, there are three eyewitnesses. Now help me with this. Are we going to plead him when there are three eyewitnesses? eyewitness identification witnesses? Why? Huh?
Too many inconsistencies.
Too many inconsistencies. Yeah. Now, what are we going to do with inconsistencies? And then we'll get back to that point. Lawyer talk is what? To tell the jury that the witness was inconsistent. There were 5 inconsistencies. To us, that makes our heart race, right? 5 inconsistencies. Or does it? That's lawyer language. Inconsistencies. It is a what? An abstraction. Yeah. It doesn't have much power at all. So, help me. We do have 5 inconsistencies, okay? How are we going to argue that to the jury?
5 different people.
Okay, 5 different people. Huh?
5 different views.
5 different views,
5 versions.
5 versions. None of this is raising my pulse rate,
These
folks.
people can't even agree about what happened.
They
Oh,
were
Making
wrong.
identification.
They were wrong.
Ah, now we're making progress,
What'd she say?
okay?
They were wrong.
They were wrong. Okay? So there is a block, a chapter in that closing argument when we take on the witness Jones. And we say the prosecutor is relying on the witness Jones to bring certainty to you that Johnny is guilty. You recall that the witness Jones, as to point number 1, said A one time and non-A on cross-examination. The witness Jones was what? Wrong. One time or the other. As to point number 2, okay? Inconsistency. The witness Jones was wrong a second time. One time or the other. And we had pictures of the physical scene. And the witness Jones testified contrary to the photograph that we have of what actually exists. Once again, the witness Jones was wrong. Inconsistency number 3, wrong. Okay, on through. And ladies and gentlemen of the jury, should you convict Johnny on the basis of the testimony of Mr. Jones? And it turns out that Mr. Jones was wrong when he pointed to Johnny and said he was the robber. Like he was wrong as to number 1, number 2, number 3, number 4, number 5. If Mr. Jones was wrong when he pointed to Johnny and said that he was the robber, like he was wrong right here on this witness stand, 5 different times, and you convict on the basis of the testimony of Mr. Johnson, and turns out wrong on that. On Johnny's being the robber, like he was on these other things. Yeah, I'm overdoing for emphasis. Then your verdict will be wrong. And you will have convicted an innocent man. So that's what you do with inconsistency. So, you are working from day one in that case, at the preliminary hearing, investigator talking to the witness, whatever statements there are, whatever discovery, you are looking for inconsistencies because these inconsistencies are going to kill the star eyewitness identifier. Over and over again, when I was in the public defender's office, I'd ask the investigator to go out and take a picture of the scene. And of course, the investigator would say, why? What are you going to use it for? And I would say, I don't know. All I know is that I've never been through a trial yet, but the witnesses testified contrary to photographs, which are in the evidence and go back into the jury. Now, what's going on in this process that I'm talking about? We are taking that eyewitness identifier. And this eyewitness identifier, the star witness, is in our focus, and we are going to define this person as somebody who makes mistakes, as somebody who made a mistake in this particular case, as somebody we cannot rely on, as somebody who was wrong. In the Kobe Bryant case, my two friends from the beginning focused on what? Consent. And that meant the testimony of this young lady, because if this young lady's testimony was correct and the jury accepted it, Kobe Bryant was going to jail. They focused with a lot more money than you have. Al hadn't said to me, I can't even stand it with everything I ask for, I get. But it's this focus on this witness and this chapter or chapters that you are going to have on this witness. Okay? And by the time you finish that, you are going to have scared the hell out of the jury about the possibility of convicting on the basis of this testimony. Now, let's talk about a few other things that we need to build into our, well, first of all, any questions about the kind of case we're going to build? And it isn't just a series of reasonable doubts or something like this. We have a formula for defeating the certainty with uncertainty, and how suggestion and reassurance led to the certainty which occurs right here in trial. Now, most of us do not get that deep, and what I am saying to you is that we need to get deeper, not rely so much on the legalities. And, you know, you can divide the task. I did this on the ID case, gave it to other people. Deja, I think it is going to be either now or later in the day down the hall, and she has learned to put together cases that defeat confessions or statements. Circumstantial evidence cases. What are you going to do with the circumstantial evidence case? Well, number one, not you, understand, but my attorneys back home. they often get the prosecution's discovery and buy it. They accept the prosecution's verdict. There's a tendency, it's imprinted. You're going to say, yep, this is what they're saying, but here's how I can get around it, here's how I can defeat it. Circumstantial evidence, there is an innocent explanation for their evidence. Am I going to tell you 100% every time? Sometimes it's pretty darn hard. But circumstantial evidence is not all that strong because there almost always is innocent explanations. And where you say, you don't say, well, that creates a reasonable doubt, but you say, this is how it happened, the innocent explanation. And unless the jury can refute your explanation, and you have created the fear of convicting an innocent person, until the jury feels that they can refute it, they're not likely to convict. Because the test is not whether there's been proof beyond a reasonable doubt. I will suggest to you that the real test as to whether jurors convict or not is this. Our conscience is going to bother us if we let a guilty man go free. Our conscience is going to bother us if we convict an innocent man. How that works out determines what occurs. And if they can convict Johnny and sleep tonight, they're very likely to convict. You want to make it so they can't sleep tonight. That's what it's like. Okay, let's take up a few other things. Strategic concessions. Strategic concessions. Let's go back to Mrs. Hurt. Mrs. Hurt watched her husband being shot. It's the toughest cross-examination I ever did because I had to conduct that cross-examination without her ever shedding tears. And so I would take her a certain distance and I'd see the emotion rising, then I had to back off and talk about something else and then come at it again. And I did get through the day with no tears for Mrs. Hurt. But how do we feel about Mrs. Hurt?
Sympathetic.
Yeah. It's so easy for us to conduct criminal defense on the basis of not liking. I conduct criminal defense on the basis of love. So Mrs. Hurt was my friend. Truly. In only one murder case have I tried where the family was not my friend. It doesn't hurt, it helps. So, now the prosecutor has this great speech about Mrs. Hurt and the horrible crime that took place. I don't want that to be the subject in the jury deliberation room. I don't want that jury thinking that they are doing something about crime in this community by convicting. So, I need to take care of this problem. And I need to let the jury know that there is no one in this courtroom who cares for Mrs. Hurt more than I do. and mean it. There is no one in this courtroom who is more against murder than I am. I mean it. A lot less enemies out there. And it takes the wind out of the prosecution's sails. Because you have out-sympathized. After I do that, they never play the sympathy game. Because they cannot feel it. I've never seen it a single time. And it may be, and is for many of us, difficult. But if we cannot do the actual feeding, I can cry for you in 30 seconds if I want to. I'm going to. If you cannot do the actual feeding, at least do the words. And mean it. And you will be well on your way of making it so that if they harp on that aspect of it, the jury sees that they are pandering to the jury, they're playing the fear game, which we're going to have played, but much more sophisticated. Okay. So we are going to make strategic concessions. It may be in cases, and I've used murder case, but there are all the other cases. The lesser includeds are often a way to defeat major things. I can't tell you how many cases in the public defender's office I got simple assault, battery, submitted, where my defendant had filled the other guy full of holes. But somehow he lived, okay? Because the jury doesn't distinguish that much between grades of felonies and misdemeanors and so forth, and they don't want to let somebody, their mother hen, they do not want to let somebody who needs to be punished go free. In the case I was talking about, Johnny was caught with a gun, not the gun that was used to kill Mr. Hurd. But I gave Johnny hell in closing argument for carrying a gun. Why? Because I wanted to take that aspect away from the jury so that the jury wouldn't get in the jury deliberation room and say, he carries a gun, we may not care whether he is guilty of murder or not. We get him off the street. Okay, because their level of dealing with this is not sophisticated many times, the jury. By the way, I should tell you that the description in Johnny's case was 6'2", 180 pounds. My defendant was about my height. Weighed about 150 pounds. And here I have this argument. Here's the description, 6'2" and 180 pounds, and I've got this defendant. And so you want to look for that kind of thing. And I was wondering, even myself, because I know the witnesses aren't very good. I met the defendant's brother, who was about 6'2" and 180 pounds. Built kind of like a linebacker. And I said to myself, this is the murderer. Without my coaching, he sat in the back of the room throughout the trial. And the jurors were looking back there. and I think, say, the real murderer is right back there. Okay, some other things we want to think about here. Because, now notice these are practical considerations. Because if Johnny didn't do it, there's somebody out on the street, isn't there? And so you build into your closing argument someplace on the streets of Los Angeles, or Canada, New York, someplace out there walks the real robber, the real murderer, the one who pulled the trigger. Someplace, but not in this courtroom. Okay? And so you need to convict somebody else, not your defendant, because the jury has focus where? Yeah, on your defendant. And they're not thinking about solving the whole case. Someone asked about experts a while ago. If, and I think that if there's an ID case, you're entitled to it, but there may be judges who don't agree. But the more you have an attack, that is where you have a case against the prosecution's case, the more likely you are to get a judge to give you the money for an expert witness. And what the expert witness will do is to take the stand and show the science of eyewitness identification and show how unscientific it is. Yes?
I was just wondering, are there any books that you would recommend that we could read about this as well? Because I'm the only one from my office here, and I know that I'm not going to be able to explain this like you have.
I have done it a few times. Okay. Don't forget your point. Since I've jerked the rug from under you using reasonable doubt, burden of proof, and all of that kind of thing, yeah, I am making it harder for you. Get books on crime scene investigation. Get books. And I hope what you do is have files, if you don't already, on these different subjects. Even fingerprints. I think his name was Brandon Mayfield. He gets arrested for blowing up things as a terrorist in Spain. He was never there. Arrested on the basis of a fingerprint. Forensic evidence. When I look into forensic evidence, no, it's so easy to say. There were fingerprints, there was the bullets matched, all that kind of thing. Don't believe it. First of all, there's science out there, but many of the experts are either tremendously overworked or don't know what they're doing. I remember our holding a mock celebration party when there was someone who had been testifying experts in drug cases and so forth, and he finally actually graduated from college. Okay. A little sarcasm on our part. But watch CSI. Look, your television bills ought to be deductible after this, okay? Because you are watching CSI to actually learn what goes on there. Now, don't take it as gospel, but they do have advisors who are helping them. And when you go in and you know these areas, you're going to have a tremendous advantage in putting this together. notice when Deja was describing about confessions yesterday, the studies that had been made, and Sunwolf, the studies, of course, basically relating to trial. So I'm jerking the rug from under you in certain respects and suggesting that you start working more to learn these areas. It doesn't take very much, and you can defeat the other side, particularly if you stick to that which you know and don't get off into areas that you don't know. What kind of jurors do we want? The ID case. There are people who walk the face of the earth who say, somebody said, somebody identified, good enough for me. Particularly if it's a minority who happens to be the defendant in the case. So, in general, I would say, use judgment about who are the jurors. But in an ID case, unless they are an authoritarian person on your side, I'm not sure I've seen many of these, okay? Unless they are an authoritarian person on your side, if they are authoritarian, you want them off the jury. You want people who have doubts. You want people who think. You want people who aren't sure. And then you're going to enhance those doubts. Who else do we want on the jury? Passionate people. Yeah.
Scientists. They recreate an experiment to confirm what has happened.
Okay.
So the more testing that's done, it comes up with a different response, disproves certainty.
Okay. And think about this one way or the other, because they could be the foreman of the jury and then some against you. They can be for you. That gets to be a tough row to hoe. And who's on the jury makes a difference. I'll give you a little example. Maybe you've read in the paper about Joe Naccio, who was head of Quest, which is a baby bell. And he was tried in Denver not long ago for insider trading. And Joe Naccio, and there's a lesson here that has nothing to do with my topic. He is being prosecuted for insider trading. And guess who were the witnesses against him? They were people that he had made millionaires. And they were testifying against him. My point here is, never turn your back on anybody. Never count on anybody not testifying against you, including your defendants. But in that case, Herb Stern, and many of you have read his books, okay, left on the jury a United Airlines pilot. Now, this was a case that was complicated financially. It was a case that my estimation was, whoever does the best lawyering is going to win. It was winnable on either side. Herb left a United Airlines pilot on that jury. Now, what happens with pilots? They have been trained and trained and trained and trained to solve problems. To take whatever time it's necessary. If they have only gas for 2 more hours in the air to solve this problem, they're still going to go through a methodical process to decide what to do. We've got the United Airlines pilot there, and those of us on the outside soon knew that the United Airlines pilot was the foreman. And then one day passes, and 2 days pass, and I say to my wife, what's going on in that jury deliberation room? And I think I have made the point, right, that the real battle takes place in the jury deliberation room. All you are doing is furnishing ammunition and gaining forces for your side. That's where it takes place. And I said, that United Airlines pilot has charts put around that jury deliberation room. They are taking this case apart, bit by bit by bit by bit. Then, the prediction shifts from the defense winning to if the airline pilot is doing that with that jury, how's it going to come out? So, who you leave on that jury, tremendously important. Use your gut. It's a precision instrument as to who you want on that jury. You want people who will buy your theory of the case, that there was a misidentification. And then in cross-examination, the vague description cross-examination, the vague description cross-examination. What are the descriptions in virtually every ID case? It's a vague description, isn't it? It's often wrong. But wrong is one thing. That is, in my case, the guy was about 5'10" as opposed to 6'2". He was about 150 pounds as opposed to 180 pounds. A tremendous argument can be made there. But in addition to that, the vagueness, when somebody says what he was about, tells the police officer he was about 6 feet tall, and he had khaki pants, and I think he might have had a beard or something like that. Okay? How many precise descriptions have you seen? Very, very few. Yeah. And if they're precise, they're likely to be what? Wrong. Yes. But you're going to conduct that vague description cross-examination. Here it is, so vague. And you're going to conduct that cross-examination showing that the police officer had a form. And you wanted to help the police officer. And the police officer gave you time to help. And the police officer was asking you questions. And the police officer was writing down your answers. And the police officers were asking you if you had any additional information. And that was all you came up with. Goes to what? The uncertainty. And you're never going to let the jury forget that that's all this person could remember. And the detective gave you his phone number. And if you had any additional ideas, you could call the detective and tell him. And you wanted to help. You wanted to give every bit of the information you could. But you didn't call the detective because nothing more came to mind. the defendant on the stand? I know that there are those who say the jury wants to hear from the defendant. But once you start the kind of attacking case that I am talking about and building your own case, it's been a long time since any juror said, we wanted to hear from the defendant. So a good deal of what we're talking about is putting the emphasis where you want it. And when you put the emphasis on what's wrong with the prosecution's case, nobody seems too concerned about the fact that the defendant did not take the stand. But there are a few defendants who by themselves can win their cases. And that's the reason that every defendant I'm going to cross-examine to see if they happen to be that good. And now and then you find one who can win his own case. You want a final appeal on your closing argument. What I mean by final appeal is that you have these arguments, including the destruction of the eyewitness, including that there's somebody else, the real robber, walking out there, etc., including things not done by the police in the investigation. Imagine that you're the world's greatest detective, and these are the things that should have been done that from your standpoint could have demonstrated that Johnny wasn't the one, and they didn't do it. It's been a long time since I haven't conducted a things not done cross-examination, because it wins cases. Even before CSI said this is the great way that cases ought to be tried. And then this final appeal. It's the last part of the closing argument. It is designed to hook the jury. And it goes something like this. Now, some of you will try to take it down, and I have seen people try to give it in my words. I will tell you, it doesn't work that way, folks. If you want to take the idea and make it your own, then you have something going for you. But it goes something like this. There are 16 instructions, and I'm not going to take the time to go through them. There is one instruction that I would like for you to take a look at. And that's the instruction on reasonable doubt, which goes to show you that I do use reasonable doubt, but it just isn't central. That instruction tells you, and here you pick out the best words out of it. It's the kind of thing that in the important things in life would cause you to hesitate and pause. Or some of you had the instruction about essentially morality. Whatever it is that is the best. But don't dwell on it. That instruction, as a matter of fact, every single thing that we have done in this trial has been for one purpose and one purpose only. And that's to ensure that no innocent person is going to be unjustly punished. That's all I do ask of you. That's all Johnny asks of you. But when you finish your deliberations, that you can say in your heart, in your mind, and in your conscience that no innocent person than just to convict. Thank you so very much. Okay. It goes back to the innocent person. If there's no response by the jury at that point in the game, send somebody else to take it.
Yeah.
Because it's not going to be, not going to be. We got a minute or two, and incidentally, there are more things to talk about than you can talk about in these 2 hours. But notice that the legalisms don't have that much to do with it. You are going to fight this proactively. You are not going to be defensive. You're not depending on the burden of proof being on the prosecutor. You are not taking the humanity out of your case. You're taking care of the characters, and you're building a case that makes sense to the jury. And it starts with Johnny is innocent. Here's how Johnny is innocent. And the kind of thinking that it takes to come up with something like this that furnishes the heart of the case. Ladies and gentlemen, how did it happen that it went from uncertainty to certainty? And let the jury know how it happened. It's real. The jurors can't get around it. This is the way that it happens. And you're going to win not only ID cases, but other kinds of cases as well, where you do the brainstorming and the creativity that is necessary to come up with defense cases. And a number of you showed up here today. I appreciate it. I applaud you. I wish you the very best.
Oh, yeah? No. Oh, yeah.
Turn that off.
Yeah, they tend to. What do they